Hey out there, legal warriors. It's the end of 2024, the start of 2025. So I wanted to put out a video about the best tips and the most popular videos from 2024. I appreciate all of your support. I know that we're learning a lot. Hopefully we don't ever need this information if we're charged with a crime, but I want you to go through the best tips, and I'm going to be there for you in 2025. So if you're interested in the criminal law, if you're interested in learning what the best was in 2024, stay tuned. This is the video for you. If you've watched this channel for a while, you might realize about 2 years ago, I did a video about the 4 agreements. And given what's going on in today's world, all the stress, all the strife, the population that we serve is particularly troubled. I think the population we exist in is particularly troubled. And driving back from court today, I thought, what really matters to me? What really matters to me is helping others heal, helping others get through the day. And one thing that made a huge difference for me and does make a difference when I share it with my clients is a book that I read a long time ago called The 4 Agreements. That's a book by Don Miguel Ruiz, and it's basically, sort of a guide to life. It's a little bit woo-woo in certain things, but I found it very useful, and it's so useful I've sewn one agreement into each one of my suits to try to help me get through this stressful time. So in this video, I'm going to cover sort of what that's about, how it is you can use the agreements in a criminal case or to help support your loved one in a criminal case, because this is a criminal law channel, but it also applies to other areas. So what are the 4 agreements? Well, first of all, what's an agreement? I think of an agreement as sort of a rule that you think is true for you. It could be, hey, I don't like mushrooms, so I haven't made an agreement that I don't like mushrooms. That used to be me, right? And whatever power we give to that agreement is how much it controls us. And so one day I decided to try mushrooms. Now I like mushrooms. And so I sort of broke that agreement so that power now can go somewhere else. And that's a simplistic version. It could be you might believe because someone said something mean to you one day that you can't sing, that you're a terrible singer. Maybe your mom was having a bad day when you were a little kid and she said, "Shut up, your voice is terrible." Well, you may have internalized that you have a terrible voice when it may not be true. And so the agreement that you've made with yourself sort of carries that negative way of seeing things, oftentimes about ourselves. It could be about others throughout the world. So it's sort of a way we see the world, oftentimes that can be harmful to us. And so what are the 4 agreements in this book? Well, the ones to sort of live by to help improve the way you see the world, to help improve the way you see stressful situations, and criminal cases are pretty stressful situations. So the 4 agreements, 1 is be impeccable with your word. 2 is to don't make assumptions. 3 is to don't take anything personally. And 4 is to always do your best. How do us defense attorneys negotiate with prosecutors? And there's going to be several different ways that happens, and it may vary, of course, by the style of whatever particular defense attorney that you've hired. I think the main way that, way one, I'm going to say, that we will negotiate with the prosecutor is it's sort of a process over time. You originally talk to a prosecutor about, hey, what's your initial position in this case, right? Because you don't want to start out too high, like, hey, I think my client did something like this, when the prosecutor thinks maybe it's less serious, right? We don't know, because each prosecutor has their own life experiences where they have different, judgment values about what's really bad or what's not really bad. An example, I started the first 7 years of my career as a prosecutor. For some reason, I didn't really like taggers, right? If you made graffiti on somebody's fence, or you tagged all this public property, that made me more mad than it made some other prosecutors. And so each prosecutor has their own idea of what sort of they want to respond to more. Now, if you came to me with a $5 candy bars, set of candy bars you stole, well, I might be less mad about that. And so it's generally good for the defense attorney first to get an idea of where the prosecutor's head is on a case, so we know where the starting line is. It'd be like if you're buying a house, right? You ask what the selling price is. You don't make an offer way above that when they want less than that. So it's sort of over time, we want to see where the prosecutor is and also learn what we can do to sort of push them towards a direction that's more favorable for the client. So that's the second way that I think we do things, besides just being over time, is having our client do some affirmative things so we're in a better position to negotiate with the prosecutor. Right? When a prosecutor offers to dismiss a case or let someone go, it's not necessarily because they didn't think something happened. Right? It's not because they make a determination. Usually it's not that the client's innocent. It's because, hey, it's my job to do justice as a prosecutor, and justice doesn't always require a conviction. And I may have too big of a caseload to try to convict everybody. So I have to make some judgment calls about where the resources of the government are going to be put to go after someone fully and to try to really crush them and punish them versus try to respond to the case in some other way. And so if you know your prosecutor really is impressed with domestic violence treatment, DVMRT treatment, well, we're likely, as part of negotiation, going to have our client do DVMRT treatment so we can say, look, we've had our client do something that will really make a difference for them, and they're not likely to be here again. So they're a better risk to give some type of offer that ends with a dismissal. We get the question, Lance, will it show up on a background check? Will it show up on my record? And I finally probably have figured out how to answer that question. And here's how I typically answer it. Regarding your record, record is sort of a no-no word to me. Record to me means a recording of an event, and that sort of relates to background checks as well. So there's only one place in Washington State that maintains your official criminal history, and that's the Washington State Patrol. And they will record arrests that have fingerprints and convictions. And so if you don't have an arrest with fingerprints or you don't have a conviction, it's most likely not going to show up on your official criminal history. Again, I'm not using that word record. Okay, I can say rap sheet, which might be slang, but let's say official criminal history. So what about a background check, Lance? Will this show up on a background check? And let me tell you, this is just pretty upsetting to us attorneys when we hear this because we want to give the best answer, but it's sort of a trick question. There's really no uniform background check out there. That's just words again. So, if you're applying for a job or applying for an apartment and they tell you they're going to do a background check, what does that mean? What service are they going to use? Are they going to be going to the State Patrol and checking just for your criminal history? Or are they going to the Washington court system and typing your name in and seeing what civil lawsuit you have against you as well? Or are they going to get on the internet and say, I'm going to find a background check company and find some business that's in the business of collecting data? And as you might guess, it's pretty easy for big business to collect big data nowadays. And the best way I can explain it, and I explain it to our clients or potential clients, I explain it like this. There's a law in Washington State that says that you can get non-conviction data deleted from your official criminal history, again, only maintained by the State Patrol, by sending in a certain form at a certain time if you qualify. And you can find that on the Washington State Patrol website. So now a background check, if that goes to the company that does big data, let's imagine that that I have a company. It's Devin and Lance's legal background check company. And Devin and Lance's, we'll call it DNL. We set up this business, and because we want to make money. Now, this is just a hypothetical. I do not have this business. We set up this business to make money, and we're going to find the best ways to collect all the data we can from all the sources of courts. Now, anytime someone goes to court, we collect it and put it in our database. Anytime there's a result, we collect it and put it in our database. There's a parking ticket, we collect it and we put it in our database. We set up automations to do that. We get really, really good and spend a whole lot of money at collecting data about people and putting it in our database. Now what do? Well, how are we going to make money from this? Well, we better advertise it. Let's put it on the internet and say, hey, come to DNL's background check company. We'll give you a year's access really cheap. Employer, you can run as many searches as you want for our data. So what does that tell you? Well, we spend a lot of money collecting our intellectual property, this data. We're going to report anything we can find because we want to keep our customers who are trying to do these background checks happy. And are we ever going to change our data? Are we ever going to delete our data that's making us money if there's not a law that requires us to? Of course not. We're never deleting that data. Then there's going to be three primary methods that I see and that I think the entire defense bar uses to try to get domestic violence cases dismissed. And I think the first method that most of us use is some form of negotiation. And negotiation doesn't mean negotiating with the alleged victim. They're not a party to the case. The alleged victim, believe it or not, is just a witness. The party to the case is the defendant, that's you if you're charged with the crime, and then the government as represented by a prosecuting attorney. It could be a county prosecuting someone, it could be a city, but there'll be someone representing the government, and your defense attorney will oftentimes try to negotiate with the prosecuting attorney to come up with a certain result. And if you've been a viewer of this channel for a while, you might guess what some of those negotiating factors might be, but let's just go down the factors that your attorney might use one by one. I think the first thing that the attorney will use, and many people think about this, so it may not be the primary thing, is looking at the police report and looking at the 911 call and finding out what the strengths and weaknesses of the prosecutor's case is versus what your version is, right? What did the police see? What did the police write? Were there any injuries? Was there any broken property? Who are the witnesses? Is it just the defendant and the alleged victim? Are they the only witnesses? Are there any aggravating factors? Things like that. Now, again, the fact pattern, believe it or not, is not the end-all, be-all in the negotiating phase of the case, because the prosecutor has hundreds and hundreds of cases they have to deal with. They're not going to fine-tooth every little detail in the report and try to see it your way. Hopefully, your attorney approaches it from a broad perspective. Hey, here's some of the weaknesses. Here's some of our version. Here's why maybe we should try to work out a resolution in this case, either because prosecutor, you might lose the trial, or do you really want to go through, a week-long trial for this particular fact pattern? So, number one in negotiation is you look at what the allegations are and what the strengths or weaknesses at a general level are of those allegations. The second thing, and I think this is more important from my perspective, is the actions of the defendant can influence, after the charge, the actions of the defendant can influence the prosecutor's willingness to be willing to resolve the case without a criminal conviction, to get some type of dismissal in the case. And why does that make sense? And what do I mean by actions? Well, by actions, I usually mean some type of classes. For domestic violence charge, it might be DV, MRT, domestic violence moral recognition therapy, basically 6 months of classes once a week, very inexpensive, sort of the gold standard now in Washington State, because it's an objective type of class versus subjective type of classes. Subjective classes, in my opinion, are what you might end up doing if you're forced to do a state-certified domestic violence batterers treatment evaluation. In my opinion, those are almost always come out the same way. 52 weeks of weekly treatment. You have to go in and say certain things, or they'll be found not in compliance because you're not accepting responsibility, even though maybe you're not guilty of anything. So, but classes, if you're taking some proactive action, now the prosecutor can feel that they're part of the solution, right? I recently have been helping people that are subpoenaed to court as a witness. And when people get subpoenaed to court for a witness, as lawyers basically think it's no big deal. But guess what? I found out if someone is subpoenaed to court as a witness to that person subpoenaed, it is a pretty big deal. You might be anxious, you might be confused, you might want to know if you even have to go to court because we have other things to do. So in this video, I'm going to cover what to expect before, during, and after court. So before court, what to expect? Well, if you've been subpoenaed to court, that means you've been given some type of document, either in the mail or in person, telling you to go to a court date on a certain time, at a certain place, and obviously on a certain date to give evidence. Now, you might be subpoenaed by the prosecution in the criminal case. You might be subpoenaed by the defense in a criminal case, or you could be subpoenaed in a civil case. And I'm not here to talk about civil cases because I'm not a civil attorney. I'm a criminal defense attorney. But most of the time, you're going to get a subpoena from the prosecutor. It's going to tell you where to go and what to do. And if you have a subpoena from the prosecutor, I want you to look closely at the subpoena and make sure that you actually have to show up. Because sometimes there's instructions that the prosecutor wants you to call a certain phone number to see if the trial is even going to go. Because a little known secret is that the prosecutor has to subpoena their witnesses every time a trial date is set for every case they have, even though they know it's not likely to go to trial. And so when I used to be a prosecutor, which I was for 7 years, I would have a stack of subpoenas that I'd sign and sign and sign, knowing that the witness was never going to have to show up. So number one, make sure you look at that subpoena. This is what you should expect before court. See if there's anyone you're supposed to contact to find out if the jury trial is actually going or the motion is actually going on the date that it's supposed to, because almost always it's not. A case might get set for trial 1 time, 2 times, 10 times, which means 1 times, 2 times, 10 subpoenas you might get, which is really annoying, and it'll still probably never go to trial. But let's say you get a message, you learn that the case is going to trial. Well, now you need to ask the prosecutor or the defense, whoever's subpoenaing you, when do you actually need me? Because if it's a felony case, it may be a multiple day trial. And in a multiple day trial, you're not going to be needed on every day. If we ever watch trials on TV, stuff like that, or on YouTube, we could see that, it takes a day or 2 to select a jury. There's a whole bunch of witnesses. They're typically going to subpoena you for the first day of trial, even though you're not actually going to be needed then, most likely. So if you found this useful, please like and please subscribe. More people get to see it. More people get the help they need. And more importantly, if you have a criminal matter in Washington State, you can feel free to reach out to my firm. We've been doing this more than 20 years. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.